Some major breaking news just into us with former President Donald Trump now facing new charges in the special counsel's investigation into those classified documents found at Mar-a-Lago. We are getting some significant new information from what's being called a superseding indictment, essentially additional information that the special counsel's office is now revealing. And it is new insight here into what specifically is being alleged related to what you just heard Laura and Lester and Danny and our team talking about. And that is the allegation that Carlos de Oliveira, identified as a property manager, a kind of maintenance worker at Mar-a-Lago, along with Walt Nada, Mr. Trump's body man, and Mr. Trump himself, tried to delete surveillance footage at Mar-a-Lago in the summer of 2022.
Hey everyone, Adam here, and we're back with another one. A federal judge read Trump's deleted private messages aloud in court has sparked dramatic reactions online. But the actual courtroom moment, while significant, was less theatrical. The scene has been exaggerated in the retelling. But here is the thing that everybody needs to understand right now. That specific scene, that exact dramatic moment, never actually happened. Not even close. And I know that might be disappointing to hear because the headline is so perfectly crafted to get your adrenaline pumping. But what actually went down behind the scenes is honestly more fascinating and way more important than some theatrical courtroom performance. Because the real story involves federal warrants, back-end server data, deleted content that was never really deleted at all, and a legal fight that tells you everything you need to know about how digital evidence actually works in major investigations. And once you understand what really happened, you will realize that the truth is actually more unsettling than any dramatic reading could ever be.
Today, Donald Trump ripping into new charges against him over his alleged corrupt attempt to delete security camera footage at Mar-a-Lago to, quote, prevent the footage from being provided to a federal grand jury.
This is harassment. This is election interference.
The former president saying in an interview with Breitbart News he doesn't think he would have had to hand over security tapes to prosecutors.
It shouldn't even be a case. It's not a criminal case.
Trump now facing 2 new counts of obstruction of justice, defending the 2 other men also charged, aide Walt Nauta, and a new figure, Carlos de Oliveira, the property manager at Trump's Mar-a-Lago home. In the new superseding indictment, prosecutors accused de Oliveira of allegedly telling another Trump employee that the boss wanted the Mar-a-Lago security server deleted just days after a draft subpoena for footage had been sent to a Trump attorney.
Really strengthens the government's case that Donald Trump was at the center. He was the center of the spokes in the wheel for this entire endeavor.
Let me paint you the real picture starting from the very beginning. Back in 2023, something massive was brewing behind closed doors that most of the public had absolutely no idea about at the time. Special counsel Jack Smith's investigative team had been building their case connected to January 6th, and they reached a point where they needed something that would change the entire trajectory of their investigation. They needed access to Donald Trump's private Twitter direct messages. Now, think about the significance of that for just a moment. We are not talking about public tweets that anybody could scroll through and screenshot. We are talking about the private, one-on-one communications that Trump presumably believed were completely confidential, the kinds of messages that never see the light of day, the conversations that happen in the shadows of direct messaging. The prosecutors did not just casually ask for this information and receive it politely. What actually happened was a full-blown legal battle over a warrant that would grant them access to this treasure trove of private communications.
Mr. Trump continues to rage against the special counsel who, we learned yesterday, executed a warrant to seize Mr. Trump's Twitter data earlier this year. Unsealed court documents revealed that Twitter, now rebranded as X, delayed in complying with handing over that data over a provision in the warrant that prevented the company from telling Mr. Trump about it at all. Now, the company was fined $350,000 as a result of that delay. Mr. Trump called that episode an attack on his Twitter and a hit on his civil rights. No word yet on what evidence Smith was able to pull from the former president's account, which you'll remember has been dormant since he was banned from the platform after January 6th. Savannah?
And here is where it gets really interesting. Twitter, which later rebranded to X under Elon Musk's ownership, did not exactly roll over and hand everything over without a fight. The platform's legal team pushed back hard against this warrant, which tells you something significant right off the bat. This was not some routine request that got processed through standard channels. This was contested, fought over, and ultimately required legal force to compel compliance. The fact that Twitter's lawyers were willing to challenge this warrant in court suggests that they understood just how sensitive and explosive the content they were being asked to surrender actually was. Once the legal dust settled and Twitter was forced to comply, here is what prosecutors actually got their hands on. Every single direct message connected to Trump's account was handed over. Every message he ever sent. Every message he ever received.
We have some new information to bring you about a search warrant in Donald Trump's federal election interference case. We've learned that Twitter gave the special counsel at least 32 of the former president's direct messages. The warrant was sought in January and was so secret that the social media company was barred from even telling Trump about it as the process played out. CNN's Caitlin Polans has this reporting, and also with us is DOJ veteran and former associate counsel to President George W. Bush, Jamil Jaffer. So, Caitlin, it all goes down in the DMs, as the young people say. What can you tell us about this batch of direct messages that the special counsel now has?
Well, maybe it goes down in the DMs. We don't know exactly who was slipping into Donald Trump's DMs at that point in time, but we do know that there were direct messages. That was something we didn't know before, that we had known through the course of some documents coming out in this particular matter that the special counsel, after they indicted him, then they were able to publicly disclose through the court system that they got a search warrant and they obtained information from Donald Trump's Twitter account. Now we have that number of how many DMs were handed over to the special counsel's office.
And here's the part that should genuinely make your jaw drop. Even messages that were saved as drafts but never actually sent to anybody were included in the data dump. Think about that for a second. Trump typed out messages, presumably thought better of them, and decided never to hit send. He probably assumed those drafts were gone forever, existing only in his own mind and on his own device. But the platform had retained copies of those unsent drafts on their back-end servers, and when the warrant came through, those drafts became part of the evidence package. Now, let that sink in for a moment, because it is genuinely one of the most important details in this entire story. A message that somebody writes, second guesses, and decides not to send is the kind of thing that most people would consider completely private. It never reached another person. It was never visible to anybody else. It was just a fleeting thought that got typed out and then abandoned. And yet, in this case, even those unsent drafts ended up in the hands of federal investigators. That reality alone should make anybody who uses digital platforms seriously reconsider what they type, even in moments of frustration or impulsive thinking, because apparently nothing is ever truly private once it exists in digital form on a platform's servers. And then we get to the detail that ties this entire story to the headline that has been blowing up everywhere. Later reporting confirmed that deleted tweets and deleted messages were also included in the data that got turned over to investigators. This is not a case where prosecutors only got the content that was still sitting visibly on Trump's account. They got content that had been actively deleted, content that Trump presumably believed was gone forever, content that he might have deleted specifically because he did not want anybody to see it. And yet, because of how digital records actually work behind the scenes, all of that deleted content still existed somewhere, waiting to be recovered through the right legal process. This is where the disconnect between public perception and technical reality becomes absolutely critical to understand. When you hit the delete button on any platform, your screen goes through this little animation, the message vanishes, and you breathe a sigh of relief thinking that whatever you just deleted is gone for good. But behind the scenes, something completely different is actually happening. That delete button typically just removes content from your visible account, from what you and other users can see going forward. But platforms almost always retain back-end copies of that content for some period of time. Sometimes they keep it for technical reasons, because their databases are structured in ways that make permanent deletion complicated and expensive. Sometimes they keep it for legal compliance reasons, because they are required to retain certain data for a set period, specifically in case it becomes relevant to a future investigation. Either way, the end result is exactly the same. The delete button that you trust to make something disappear forever is often just a visual trick, a comfort mechanism that makes you feel like you have control over your digital footprint, when that control is actually far more limited than you realize. And when law enforcement shows up with a valid warrant, they can potentially reach into that back-end data and recover content that the user believed was long gone. That is exactly what happened in this case. Deleted content that Trump thought was gone forever ended up being handed over to federal investigators. Now, I need to stop right here and address something crucial, because this is where the headline completely derails from documented reality. Prosecutors obtaining deleted messages through a legal warrant process is a completely different thing from what the headline claims actually happened. The headline wants you to believe that a judge stood up in open court and read those exact deleted messages out loud for a stunned courtroom to hear. Those are not the same event at all. One is a quiet procedural step that happens behind closed doors as part of building a case, a standard part of the evidence-gathering process that happens in investigations every single day. The other is a dramatic courtroom spectacle that would have made headlines for entirely different reasons. And based on everything actually documented, that spectacle never happened in the way the headline describes. And just to be completely thorough about where this confusion might be coming from, there was a completely separate trial that did involve messages being read aloud in court. During Trump's hush money trial, witnesses did read text messages out loud as part of their testimony. That really happened, and it really was a dramatic moment in its own right. But those were different messages entirely, read by witnesses rather than a judge, and they were not connected to these specific deleted Twitter direct messages from the January 6th investigation. So even that real courtroom moment gets misattributed when you start mixing different cases together. Somewhere along the way, these two completely separate stories got smashed into one exaggerated headline that does not accurately represent either case on its own. Think about how easily that kind of mix-up happens once a story starts spreading further and further from the original reporting. Somebody remembers that Trump-related messages got read aloud in a courtroom at some point, which is true, but attaches that memory to the wrong case entirely. Then somebody else combines that memory with a separate real story about deleted Twitter messages being obtained through a warrant, and suddenly you have got a completely fabricated scene that never actually happened in either case. Each piece of that combined story is rooted in something real, but smashed together, they create an event that simply does not exist in the documented record. But here is the thing that makes this story genuinely important, even without the fake dramatic packaging. The fact that deleted messages and unsent drafts were included in what got handed over is honestly one of the most significant details in this entire saga. Most people assume that deleting something or never sending a draft in the first place means that content simply does not exist anymore for anybody to find. This case proves that assumption is often wrong, especially once a platform gets legally compelled to hand over back-end data connected to a formal investigation. That detail alone should make anybody think twice about what deleting something on a digital platform actually accomplishes. And think about how this applies way beyond just this one specific case. Every single day, ordinary people delete text messages, delete direct messages, delete drafts they decided not to send, all while assuming that content is simply gone forever. This story is a pretty clear reminder that assumption does not always hold up, particularly once legal processes and formal investigations get involved. That is not really about Trump specifically at that point. That is about how digital communication actually works at a technical level, regardless of who the account belongs to. The underlying lesson extends to literally anybody sending messages on any platform today. The prosecutors working under Jack Smith were not just fishing for anything they could find. They were specifically targeting communications that might shed light on the events surrounding January 6th and what Trump knew, what he said to allies, and what he might have been planning behind the scenes. Those direct messages represented a window into private conversations that had never been subject to public scrutiny. And the fact that even deleted content and unsent drafts were recoverable made that window significantly wider than Trump might have anticipated. Let me walk you through exactly why platforms even keep this back-end data in the first place. Because understanding that is key to understanding why deleted content keeps resurfacing in legal cases. Sometimes it comes down to purely technical reasons. The way databases are structured makes it expensive and complicated to permanently and immediately scrub every trace of deleted content the moment somebody hits delete. Sometimes it comes down to legal reasons, where companies are required to retain certain data for a set period specifically, in case it becomes relevant to a future investigation or legal proceeding. Either way, the end result is the same. The delete button on your screen often just hides content from view, rather than instantly and permanently destroying it everywhere it exists. Now think about how significant that actually is for anybody, not just Trump. operating under the assumption that hitting delete makes something disappear permanently. It genuinely does not always work that way, especially once a platform becomes legally required to preserve and hand over data connected to a formal investigation. This detail alone, deleted content potentially surviving and later being recoverable through legal process, is honestly one of the most important and most under-discussed parts of how modern digital investigations actually work. It is the kind of reality that should influence how careful people are about what they type, even in moments when they assume their words will never see the light of day. There is one more piece of this puzzle worth mentioning because it shows this is part of a bigger pattern, not just an isolated situation. Separate litigation involving signal messages and Secret Service-related texts has shown that courts can, in certain circumstances, order the preservation of deleted communications. That is a completely different legal situation from the Twitter warrant fight, but it reinforces the same underlying theme running through this entire story. Deleted digital communications keep showing up as legally significant evidence across multiple different cases and contexts, which is exactly why headlines about deleted messages resurfacing keep generating so much attention, even when the specific dramatic details get exaggerated or misattributed along the way. Think about why courts would even need to step in and order preservation of deleted communications in the first place. That kind of order usually happens when there is genuine concern that relevant evidence might otherwise be lost, whether through routine data deletion policies or through somebody actively trying to delete communications that could become relevant to ongoing litigation. The fact that this kind of preservation order has come up in multiple separate contexts involving different platforms and different agencies tells you this is not some rare isolated legal maneuver. It is becoming a genuinely common tool courts use specifically because digital communications keep playing such a central role in modern investigations and legal disputes. So let me be crystal clear about what we can honestly say happened here versus what the headline is trying to sell you. Prosecutors absolutely did obtain Trump's Twitter direct messages through a contested warrant process connected to the January 6th investigation. Those messages included deleted content and unsent drafts, which is a remarkable revelation about how digital data retention actually works. Separately, witnesses absolutely did read different text messages aloud during the hush money trial, which was its own dramatic courtroom moment that actually did happen. And separately still, other litigation around Signal and Secret Service texts shows courts dealing with deleted communication preservation more broadly. That is the real documented version of this story. And honestly, it is significant enough on its own without needing some invented courtroom drama to make it interesting. But here is the thing about the dramatic courtroom reading version that makes it so appealing. It plays into everything we expect from high-stakes political investigations. We want the moment of revelation, the scene where hidden truth is finally dragged into the light. We want the villain exposed, the evidence laid bare, the courtroom silenced by the weight of what is being revealed. It is the narrative structure that has been burned into our brains by every legal drama we have ever watched. And that is exactly why the headline works so well. Because it taps into that expectation and delivers what we want to believe happened, even when the reality is more procedural and less cinematic. But here is the thing about the reality that actually makes it more interesting than the fiction. The fact that deleted content can be recovered through legal warrants is genuinely unsettling in a way that a dramatic courtroom reading never could be, because a dramatic reading is a one-time event, a spectacle that happens and then fades from memory. But the reality of back-end data retention means that every single message you have ever sent, received, typed as a draft, or deleted might potentially still exist somewhere, waiting to be recovered under the right circumstances. That is the kind of reality that should genuinely make you think differently about your own digital habits, regardless of how you feel about Trump or any other political figure. The fact that Trump's draft messages were included in what got handed over is particularly significant because it shows that even the things he thought better of, the messages he reconsidered and chose never to send, were not safe from scrutiny. A draft is the most private form of digital communication there is. It never reached another person, it was never visible to anyone else. It existed only in the space between thought and action, a fleeting consideration that was ultimately rejected. And yet, even those drafts became part of the evidence package. That reality should give anyone pause about what they type, even in moments when they believe no one will ever see it. The broader implications of this case extend far beyond Trump or January 6th or any particular political investigation. This is about the fundamental nature of digital communication in the modern world. We have all been operating under the assumption that deleting something makes it go away. We have all trusted that unsent drafts remain private. We have all believed that our digital footprints are under our control. This case, along with the separate litigation involving Signal and Secret Service texts, demonstrates that those assumptions are increasingly unreliable. The platforms we use retain our data in ways we do not fully understand, and legal processes can access that data in ways we never anticipated. So, who actually benefits from how this story keeps circulating in its exaggerated form? Honestly, this cuts multiple directions. Critics of Trump benefit because a dramatic headline about deleted messages getting read aloud reinforces a narrative of hidden wrongdoing finally being exposed, even when the actual documented reality is more procedural than theatrical. Defenders benefit by being able to point out accurately that the dramatic courtroom scene never actually happened, which lets them dismiss the underlying story a little too easily, along with the exaggeration. The media benefits because a headline about a judge reading deleted messages aloud while a courtroom cannot handle it generates way more attention than the more accurate, more technical version involving warrants and back-end data and legal preservation orders. And there is a subtler kind of benefit worth mentioning too, which applies to basically anybody using digital platforms in their own daily life. Stories like this one, once you strip away the exaggeration, serve as a genuinely useful public reminder that deleted content is not always as gone as people assume. That reminder benefits ordinary people far more than it benefits anybody directly involved in this specific case, because it encourages a level of digital caution that extends well beyond politics entirely. Whether or not you care one bit about Trump specifically, the underlying lesson about how deletion actually works applies to literally anybody sending messages on any platform today. So, what happens next with this story? Do not expect some dramatic courtroom reveal to suddenly happen exactly the way the headline describes. What is more likely is that this story keeps developing through additional court filings, additional reporting on exactly what those deleted Twitter messages actually contain, and possibly further developments in the separate Signal and Secret Service preservation litigation too. The real substance of what was actually recovered is most likely to eventually become clearer through court documents and legal proceedings, not through some invented dramatic courtroom scene that never happened. There is also a decent chance that as the Signal and Secret Service litigation continues moving forward separately, we get more public clarity on exactly how courts are handling deleted communication preservation more broadly, which could end up shaping how future investigations involving Trump or anybody else approach recovering deleted digital content going forward. That broader legal precedent is honestly worth watching just as closely as whatever specific new details emerge from the January 6th investigation itself. Because the way courts handle deleted communications in these cases will set standards for how similar situations are handled in the future, and those standards will apply to everyone, not just political figures or high-profile defendants. The legal framework being built around digital evidence and deleted content is going to affect how investigations are conducted for years to come. And understanding that framework is essential for anyone who wants to understand how modern law enforcement actually works. The truth is that the real story behind this headline is more significant than any dramatic courtroom scene could ever be. It is about the collision between our assumptions about digital privacy and the technical reality of how platforms actually store our data. It is about the growing power of legal processes to reach into our digital lives and recover things we thought were gone forever. It is about the uncomfortable truth that nothing we type, send, delete, or leave unsent is ever truly private once it exists in digital form. And that is the kind of story that should matter to everyone, regardless of politics, because it touches on something fundamental about how we communicate in the modern world. The judge reading deleted messages aloud, framing in that headline, does not hold up against the actual documented reality, but the real story underneath it. A contested warrant fight that led to prosecutors obtaining Trump's deleted Twitter messages and unsent drafts. A separate hush money trial moment involving different texts read by witnesses, and a broader pattern of courts dealing with deleted digital communications across multiple cases. All of that is genuinely significant. And honestly, it tells you a lot more about how digital evidence actually works in major investigations than any invented courtroom drama ever could. That is the story worth paying attention to, not because it is dramatic, but because it is real.